The cover-up machine. There's a pattern in how truth gets buried. Not through dramatic confrontation, not through single acts of concealment, but through accumulation. Layer after layer of decisions, each one defensible on its own, that together creates something impenetrable. We've spent 7 episodes examining evidence. Physical evidence that tells a story the official narrative struggles to contain. Timeline contradictions that expand rather than resolve under scrutiny. Behavioral patterns that suggest knowledge rather than confusion. But evidence, no matter how compelling, doesn't prosecute itself. Someone has to look at what's been gathered and decide, does this warrant accountability? Does this demand answers? Does this require that uncomfortable questions be asked, even when the people being asked would prefer silence? And what happens when the answer to those questions is carefully, systematically, definitively? No. That's what we need to examine now. Not just what happened on December 26, 1996, but what happened in the days, weeks, months, and years that followed. How a case with this much evidence, this many inconsistencies, this many unanswered questions, could remain unresolved for nearly 3 decades. This isn't about assigning individual culpability. This is about understanding how investigation itself was shaped, influenced, and ultimately constrained by decisions that had nothing to do with evidence and everything to do with access, resources. Because what we're looking at isn't a failure of investigation. It's the success of something else entirely. Act 1. The first 24 hours, December 26, 1996. Let's start with the timeline. 5:52 in the morning. A 911 call reports a child missing with a ransom note left behind. Before 10:00 in the morning, an attorney arrives at the family home. 1:05 in the afternoon, the child's body is discovered in the basement. That first detail deserves attention. An attorney present before the body was even found. Not hours later, not the next day, but within the first few hours of a reported abduction. The attorney was Michael Bynum, a corporate lawyer. His presence that morning established something that would characterize this entire case: immediate legal protection preceding any formal questioning. Research on family behavior in genuine abduction cases shows a pattern of absolute cooperation with law enforcement. Parents volunteer information without hesitation, submit to any questioning that might help, provide unlimited access to investigators. The urgency of recovering their child overrides concerns about privacy or legal exposure. Resistance to cooperation tends to emerge when families possess knowledge they need to protect. By the end of that first day, several patterns had already taken shape. Multiple family members receiving separate legal representation. Not one family attorney, but individual counsel for each person potentially connected to the investigation. Extended family members, some not even present in Colorado that night, also receiving legal representation paid for by the family at the center of the case. The crime scene contaminated by foot traffic, not through investigator error, but through family decisions to invite numerous people into the home despite the ransom note's explicit warnings against contacting anyone. The father discovering the body himself, in a room that had reportedly already been checked by police earlier that morning, then immediately moving the body upstairs, destroying the scene's integrity in the process. Each of these actions, viewed individually, could have explanations. Viewed together, they form a pattern of control. Within 1 week of the investigation beginning, legal barriers were already comprehensive. Separate legal teams for the parents, separate representation for the older sibling, legal counsel provided to the father's ex-wife in Atlanta, legal counsel provided to the older children from the father's first marriage, also in Atlanta, hundreds of miles from Colorado. Think about what this distribution of legal resources suggests. People who weren't present that night, people who had no direct knowledge of events, people who lived in a different state entirely, all receiving attorneys paid for by the family. One has to ask, what information were these geographically distant family members being protected from sharing? The first week also established the communication protocol that would define the family's interaction with investigators for months. No face-to-face interviews would be granted. Instead, investigators could submit written questions via fax to the attorneys' offices. The attorneys would review these questions with their clients. Written responses would be prepared and faxed back. This wasn't standard procedure. This wasn't typical family cooperation. This was an unprecedented level of controlled communication in a case where a child had been reported missing and then found deceased in the family home. Research on interview dynamics shows that written communication eliminates the investigative value of real-time questioning. There's no opportunity to follow up on inconsistencies, no ability to observe body language or emotional responses, no chance to ask clarifying questions that might reveal information the person being questioned hadn't intended to share. Fax-only communication transforms investigation into a carefully managed exchange, where every word can be vetted by legal counsel before being released. For 4 months, from late December 1996 through April 1997, this was the only way investigators could communicate with the family. 4 months, while evidence degraded, while memories became less reliable, while the crucial early window for solving the case slowly closed. By the time face-to-face interviews were finally granted in April 1997, they came with conditions. Limited time. Specific topics, pre-approved. Attorneys present and actively involved. The ability to end questioning at any time. These weren't the conditions of a family desperate to find who took their daughter's life. These were the conditions of legal strategy designed to minimize exposure. Act 2. The legal architecture. Let's talk about the team that was assembled. The father hired Haddon, Morgan, and Foreman, one of Colorado's most prestigious criminal defense firms. The lead attorney, Hal Haddon, was known for representing high-profile clients in complex cases. His approach to defense work was sophisticated. Don't wait for charges to be filed. Shape the narrative before the case ever reaches a courtroom. Haddon's team had a reputation. Years later, they would represent Kobe Bryant during his legal troubles in Colorado. They were ranked as super lawyers by their peers, a designation reserved for attorneys in the top 5% of their profession. This wasn't a lawyer you hire to help you cooperate with police. This was a lawyer you hire when you need the best possible protection against prosecution. In a later interview, Haddon described his philosophy on high-stakes cases. The goal is to win outside the courtroom, to create enough doubt, enough alternative explanations, enough questions about the investigation itself that prosecution becomes untenable. It's a legitimate strategy. Aggressive defense is every person's right, but it tells us something about what the person hiring that defense understands about their situation. The mother received separate representation from a different firm, not as prominent as the father's team, but experienced in criminal defense. The older sibling, 9 years old at the time, received his own attorney. Separate from both parents. Think about what this structure creates. 3 separate legal teams means 3 separate attorney-client privileges. Information shared with one attorney doesn't have to be shared with the others. Strategies can be coordinated or kept isolated depending on what serves each client's interests. It creates what legal scholars call defense in depth. Layers of protection that make it nearly impossible for investigators to understand the full picture because no single person is required to provide it. But the legal architecture extended beyond the immediate family. The father's ex-wife in Atlanta. Legal representation provided. The older children from the first marriage, both in Atlanta. Legal representation provided. The pilot friend who was supposed to accompany the family to Michigan. Legal representation provided. These weren't people with direct knowledge of December 25th or 26th in Boulder, Colorado. These were peripheral figures who might be asked to provide context about family dynamics, about history, about patterns of behavior. And every single one of them was provided legal counsel that established boundaries around what they would and wouldn't discuss. The cost of this legal operation was substantial. Multiple high-powered defense teams, coordinated strategy across different firms, representation for numerous individuals, all funded by the family's resources. Research on legal strategy in criminal investigations shows that this level of legal mobilization is unusual in cases where the subjects claim to be cooperating fully with law enforcement. Typically, Families hire an attorney to ensure their rights are protected, but maintain open communication with investigators. They want the case solved. They want whoever is responsible held accountable. Legal representation serves as a safeguard, not a barrier. This was something different. This was architecture designed to control information flow, to limit investigator access, to ensure that every interaction was filtered through legal counsel who could terminate questioning if it moved in uncomfortable directions. And it worked. The investigation struggled to gain traction, not because evidence didn't exist, but because access to the people who could explain that evidence was systematically restricted. Phone records, a standard investigative tool, weren't provided until 1998, nearly 2 years after the case began. By then, the crucial early timeline had long since passed. The father's cell phone records would have shown calls made in the hours before the 911 call. Who was contacted? When? For how long? Why would it take 2 years to provide records that people wanting to find who took their daughter's life would hand over immediately? The delay wasn't explained. The records, when finally produced, perhaps the most revealing aspect of the legal strategy was how it shaped what investigators could and couldn't pursue. Consider the oldest sibling, 9 years old at the time. Under Colorado law, children under 10 years of age cannot be charged with any crime, including homicide. Even if investigators had evidence suggesting involvement, criminal prosecution wasn't legally possible. This is called the age of criminal responsibility, the minimum age at which a child can be held criminally accountable for their actions. Colorado set that age at 10. Many states set it even lower, but Colorado had made a policy decision that children under 10 lack the mental capacity to form criminal intent. So even if evidence pointed toward the older sibling, the legal system had no mechanism for prosecution. But there's something else worth considering. Even though the child couldn't be prosecuted, parents can be held accountable for actions taken after a child causes harm. If parents discover that their child has unintentionally caused another child's death, and then stage a scene to make it appear someone else was responsible, that staging, that obstruction, that false reporting, those are adult acts that carry legal consequences. This is where the legal barriers become particularly significant. The separate legal representation meant that each family member's exposure could be assessed independently. The child couldn't be charged, but the parents could be, if evidence showed they participated in covering up what happened. The legal strategy ensured that investigators could never quite assemble the full picture. Each family member's attorney controlled what information that person would provide. Questions that might reveal one family member's knowledge could be blocked if answering them might implicate another family member. It's sophisticated, it's legal, and it's incredibly effective at preventing the kind of comprehensive understanding investigators need to build a prosecutable case. Act 3. The grand jury. What they saw, and why it mattered. In 1999, after more than 2 years of investigation, Boulder District Attorney, grand juries are different from trial juries. They don't decide guilt or innocence. They decide whether there's probable cause, sufficient evidence to believe a crime was committed, and specific individuals should be charged. The standard is lower than beyond a reasonable doubt. It's more likely than not. This grand jury met for over a year. From September 1998 through October 1999, they heard testimony, reviewed evidence, and examined documents that most of the public would never see. They heard from medical examiners about the findings from the autopsy. They reviewed forensic reports about DNA, fibers, and fingerprints found at the scene. They examined the ransom note and heard expert testimony about handwriting analysis. They listened to investigators describe timeline inconsistencies and behavioral patterns. They saw crime scene photographs that revealed staging elements, the incomplete restraints, the duct tape that didn't adhere properly. They heard about the pineapple bowl with family fingerprints that no one would claim. They reviewed medical records documenting chronic concerns that had never been adequately explained by the parents. They examined the parents' changing timelines, how the account of when they arrived home and when they went to bed. They heard about the immediate legal mobilization, Attorneys present before the body was found. Fax-only communication for months. Extensive restrictions on investigator access. And after 13 months of examining this evidence, the grand jury voted not to dismiss the case, to indict. Specifically, they voted to indict both parents on 2 charges each. Count 4A. Child impairment resulting in death. And the record counts as 7. Accessory to a crime. For rendering assistance to a person with intent to hinder, delay. Read those charges carefully. The grand jury didn't charge the parents with directly causing their daughter's death. They charged them with knowingly placing her in a dangerous situation that resulted in her death, and then helping the person responsible avoid accountability. This language tells us something about what the grand jury believed happened. They believed the parents knew their daughter was in danger. They believed the parents failed to protect her from that danger. They believed someone in that environment was responsible for her death. And they believed the parents took actions to help that person avoid consequences. The grand jury foreman later spoke to media, carefully, because grand jury proceedings are secret. He said the jurors believed there was sufficient evidence to proceed with charges. They felt the evidence justified holding the parents accountable for their role in what happened. Another grand juror, speaking to media years later, said the evidence they saw was that the most difficult part was understanding how parents could make the choices the evidence suggested they'd made. But here's what happened after the grand jury voted to indict. Nothing. District Attorney Alex Hunter refused to sign the indictment. Without the DA's signature, the indictment couldn't move forward. The grand jury's decision meant nothing in practical terms. Hunter's explanation was that he didn't believe he could secure a conviction at trial, that the evidence, while sufficient for probable cause, wasn't strong enough to prove guilt beyond a reasonable doubt to a trial jury. He cited concerns about the DNA evidence that didn't match family members. He suggested that any competent defense attorney would use that DNA to create reasonable doubt, arguing that an unknown intruder was responsible. But consider what this decision meant. A grand jury, regular citizens who spent over a year reviewing evidence in detail, determined there was probable cause to believe the parents were criminally responsible for their role in their daughter's death. The chief prosecutor chose not to pursue those charges. And then, critically, the grand jury's decision was sealed. The documents showing that an indictment had been voted were locked away. The public wasn't informed. Media reports at the time stated that the grand jury had concluded its work without bringing charges. Technically true, since the DA refused to sign. For 14 years, this remained secret. It wasn't until 2013, 14 years after the grand jury voted, that a reporter successfully sued to have the indictment documents released under Colorado's open records laws. Only then did the public learn that a grand jury had indeed found probable cause to charge the parents. Only then did people understand that the no indictment narrative they'd been told for over a decade was incomplete at best, deceptive at worst. Think about what those 14 years of secrecy accomplished. Public perception solidified around the idea that a grand jury had examined the evidence and found it insufficient. This became a talking point for those defending the family. Even a grand jury didn't indict. But that wasn't true. The grand jury did indict. The DA simply refused to prosecute, and the family's legal team used those 14 years effectively. They continued the media campaign. They wrote books presenting their version of events. They sued media outlets that suggested family involvement. They shaped a narrative that treated the case as an unsolved mystery rather than a case where a grand jury had voted to hold them accountable. By the time the truth about the indictment became public in 2013, it was old news. The family had already been cleared by Damari Lacey's 28 letter. Public attention had moved on. The timing of that secrecy, whether intentional or not. Act 4. The legal barriers, statutes, restrictions, and impossibilities. Let's talk about what the law actually allows in a case like this. We've already discussed Colorado's age of criminal responsibility. Children under 10 cannot be charged with crimes. This created a fundamental barrier. Even if evidence suggested the older siblings' involvement, prosecution wasn't legally possible. But there are other legal barriers that have shaped this case, some procedural, some simply the result of time passing. First, there's the statute of limitations. For most crimes, there's a time limit on when charges can be filed. The purpose is to ensure that prosecutions happen while evidence is fresh and memories are reliable. It also reflects a policy decision that after enough time has passed, society's interest in punishment diminishes. In Colorado, there is no statute of limitations for murder. Charges could theoretically be filed decades later if new evidence emerges. But for other crimes, including the charges the grand jury actually voted on, there are time limits. The charge of child endangerment resulting in death had a 3-year statute of limitations at the time. That expired in 1999. The accessory charge had a similar limitation, also expired. Even if new evidence emerged tomorrow that conclusively proved the parents' involvement in staging the scene and helping the person responsible avoid accountability, those specific charges could no longer be filed. The window closed while the grand jury's decision remained secret. Now, there are scenarios where charges could still theoretically be filed. If evidence emerged that the parents themselves directly caused their daughter's death, not just endangered her or helped cover up what someone else did, murder charges would still be possible. But that would require evidence the investigation never conclusively developed. And developing that evidence now, nearly 30 years later, memories have faded, witnesses have aged or passed away, physical evidence has degraded. The crime scene was compromised on day one and can never be reconstructed. The legal barriers aren't just about statutes and age limits. They're about the practical reality that time itself has become a form of protection. Then there's the barrier created by the legal strategy itself. Remember the separate attorneys for each family member. Remember the facts-only communication. Remember the restrictions on what could be asked and when. All of that created something called parallel construction problems for investigators. Here's what that means. If you want to build a case against multiple people who might have acted together, you need to understand the full picture of what happened. Who did what? Who knew what? Who helped whom? But when each person has separate legal representation, and each attorney controls what their client will reveal, you can never get that full picture. You might know that person A did X. You might suspect that person B knew about X and helped hide it. But if person A won't talk about what person B knew, and person B won't talk about what person A did, you can't prove the connection between them. This is especially problematic in cases involving families, where actions might be coordinated, but each family member's attorney can claim their client acted independently. The legal strategy created a situation where, even if investigators suspected they knew what happened, proving it to the standard required for prosecution. And here's the thing. All of this is, hiring attorneys is legal. Refusing to speak to police without counsel present is legal. Invoking the Fifth Amendment right against self-incrimination is legal. Controlling what information you provide to investigators is legal. The problem isn't that the family did anything illegal by protecting themselves legally. The problem is that the legal system itself, designed to protect individual rights, can be used in ways that make finding truth nearly impossible when multiple people coordinate their legal defense. There's another barrier worth discussing. The 28 exoneration letter. When Mary Lacey wrote to the family stating that new DNA analysis had cleared them, that letter created an official record that defense attorneys could use in any future prosecution. The district attorney already determined our clients are innocent. You're trying to prosecute people who've been officially cleared. Even though Lacey later expressed regret about the letter. Even though the DNA evidence she relied on was touch DNA. That many experts consider insufficient to override all. Even though her successor has publicly disagreed with her decision to send that letter. It's in the record. It's official. And it creates a presumption of innocence that any future prosecutor would have to overcome. These layers of legal protection, age limits, statutes of limitations, parallel construction problems. Not because evidence doesn't exist, Because the legal system's protections, deployed expertly and extensively, have placed that evidence beyond the reach of criminal accountability. Act 5. The media strategy. While legal barriers were being constructed, another campaign was unfolding simultaneously. Media appearances. The family appeared on CNN within days of the funeral. Then Barbara Walters. Then other major networks. These weren't brief statements asking for public help. These were lengthy interviews designed to humanize the family, to present them as victims of both tragedy and unfair suspicion. The parents spoke about their grief, their confusion about why anyone would suspect them, their cooperation with investigators, though the actual record showed extensive restrictions on that cooperation. In a particularly notable interview with Barbara Walters in 2000, the mother cried on camera while insisting no one in the family could have harmed her daughter. She described the investigation as persecution. She presented herself as a grieving mother being victimized a second time by unjust suspicion. The father appeared calm, controlled, occasionally emotional. He spoke about his desire to find who was responsible. He expressed frustration with investigators for what he characterized as their narrow focus on the family instead of pursuing other leads. These interviews were strategic. They controlled the questions, friendly interviewers, pre-approved topics, no confrontational follow-up. They controlled the answers, prepared statements, rehearsed emotional beats, messages crafted by legal and PR advisors. And they were effective. Public sympathy grew. Media outlets began running stories questioning the investigation rather than questioning the family's account. The narrative shifted from what happened in that house to why are investigators fixated on this grieving family. But there's a contradiction here worth examining. The family repeatedly declined to speak with investigators face-to-face for months, citing privacy and legal concerns. Yet they spoke freely on national television. They wouldn't sit down with detectives who might ask uncomfortable questions about timeline inconsistencies or evidence that contradicted their account. But they would sit down with Barbara Walters, who could be counted on to ask sympathetic questions and accept their explanations without challenge. This pattern suggests something about priorities. Media appearances served a purpose that investigative interviews didn't. They allowed the family to control both questions and answers. In 2000, the family published a book, Death of Innocence. In it, they presented their version of events, their experience of that night, their frustration with the investigation, their certainty that someone unknown to them had entered their home and took their daughter's life. The book became a bestseller. It positioned them as victims not just of tragedy, but of a flawed investigation and a rush to judgment. Critics pointed out inconsistencies between what the book claimed and what evidence showed. They noted that the book presented some events differently than the family's earlier statements to police. They observed that profits from a book about their daughter's death raised questions about motives. But the family had successfully reached a mass audience with their narrative before critical analysis could take root. In 2012, the father published another book, The Other Side of Suffering, again presenting himself as a victim of tragedy and injustice, again maintaining the narrative of an unknown perpetrator, again profiting from the story while shaping public perception. And then there were the lawsuits. The family sued multiple media outlets for defamation. Not all of these lawsuits went to trial. Many settled out of court with confidentiality agreements and undisclosed financial terms. The effect of these legal actions was chilling. Journalists became cautious about how they covered the case. Questions that might once have been asked directly were softened or avoided entirely. The threat of litigation made aggressive investigation of the family's account risky for media organizations. In 2016, CBS aired a documentary called The Case of JonBenet Ramsey. The program examined evidence and consulted with experts who explored various theories about what might have happened. One segment discussed the possibility that the older sibling might have been involved in some way. The program was careful in its language. It presented this as a theory, not a conclusion. It used experts to analyze evidence. It included disclaimers about the speculative nature of the discussion. None of that mattered. The older sibling, now an adult. The case settled out of court for an undisclosed amount, but the message was clear. Examining certain theories about this case carried significant financial risk. After that settlement, coverage of the case became even more cautious. Documentaries that followed tended to focus on the unsolved mystery angle, rather than examining evidence that might point toward family involvement. The ones that did examine such evidence were careful to include multiple alternative theories and extensive disclaimers. The combination of legal strategy and media management had achieved something that court proceedings alone might not have: effective immunity from serious public scrutiny. Think about what this means for truth-seeking. If investigating certain theories carries million-dollar liability risk, who's going to investigate those theories? If presenting evidence in ways that suggest family involvement results in expensive litigation, who's going to present that evidence? If the consequences of questioning the official narrative are financial devastation, how many journalists are going to question that narrative? The legal system is supposed to protect truth. The discovery process and trial. But if cases never make it to trial because the cost of suggesting certain possibilities is prohibitive, truth gets buried under liability risk. This is how legal strategy and media management work together. The legal barriers prevent criminal accountability. The media strategy prevents public accountability. And the threat of defamation suits prevents journalistic accountability. What's left is a narrative carefully curated by the people who most benefit from that curation. Act 6. Where we are now. 2024. Nearly 3 decades later, here's what we know. The case remains officially unsolved. No one has been charged. The father, now in his 80s, continues to maintain that someone unknown to the family was responsible. He's participated in multiple recent documentaries presenting the case as an unsolved mystery. A Netflix documentary in 2024 featured the father extensively. He called for renewed investigation using modern DNA technology. He insisted that if investigators would just properly test all the evidence, they would find the unknown intruder he's maintained was responsible all along. The documentary presented his perspective sympathetically. It focused on his grief, his frustration with the investigation, his persistence in seeking justice for his daughter. What it didn't focus on was the evidence that's been sitting in files for decades. The pineapple bowl, the ransom note written on materials from inside the home, the timeline contradictions, the medical findings, the staging elements, the grand jury indictment that was hidden for 14 years. The older sibling lives privately, rarely speaking publicly, protected by the legal precedent established in 2016 that makes questioning his potential involvement financially dangerous for media organizations. The mother passed away in 26 from ovarian cancer. Whatever she knew, whatever she might eventually revealed, went with her. The evidence we do have access to tells a story. Forensic reports showing family DNA throughout the scene, patterns that require explanation. The pineapple bowl with family fingerprints that no one will claim. Medical findings documenting both chronic and acute concerns that were never adequately explained. Timeline inconsistencies that grew rather than resolved as the family revised their accounts. The ransom note written on materials from inside the home, in handwriting that experts found remarkably similar to the mother's own. A grand jury that voted to indict but whose decision was overridden by a DA who chose not to prosecute. All of this evidence sits in files, available to anyone who looks, telling a story that the official narrative has spent decades trying to obscure. But here's what we also have to confront: the legal realities of this case. The older sibling was 9 years old at the time. Under Colorado law, a child that young cannot be prosecuted for homicide. Even if evidence conclusively pointed to involvement, criminal charges were never a possibility. The statute of limitations on the charges the grand jury actually voted on, child endangerment and accessory to a crime, expired years ago. The mother is deceased. The father, now in his 80s, continues to maintain innocence and has the legal resources to challenge any accusations. So when we talk about justice in this case, We have to be honest about what that means. It doesn't mean criminal prosecution. That window closed years ago, if it was ever truly open. What it means is truth. Recognition of what the evidence actually shows. Acknowledgement of how the investigation was systematically impeded. Understanding of how legal strategy and media management can create an alternative reality that overrides physical evidence. The legal system failed this case. Not because investigators didn't gather evidence, but because access to the people who could explain that evidence was controlled so effectively that prosecution became impossible. Money bought legal expertise that ordinary families don't have access to. That expertise constructed barriers that protected individuals from ever having to answer uncomfortable questions under circumstances where those answers might be used against them. It's not illegal. It's not even unusual for people with resources to hire the best legal representation available. But it does create a two-tiered system. One for people who can afford sophisticated legal defense that shapes investigation from the very beginning. Another for people who can't. And when we look at this case, nearly 30 years later, what we see is the success of that two-tiered system. Evidence that would compel investigation in cases without resources was systematically compartmentalized behind legal barriers. Timelines that would require explanation from families without legal teams were allowed to shift and change without consequence. Behaviors that would raise immediate suspicion in cases involving ordinary people were reframed as understandable grief and reasonable caution. Closing. What we owe. There's a 6-year-old girl at the center of this. Not a mystery to be solved. Not a true crime story to be consumed. A child who lived in a house where something went terribly wrong on Christmas night. In 1996, she was found in her own basement, wrapped in her own blanket, surrounded by items from her own home, in circumstances that required someone with intimate knowledge of where things were kept and how the family functioned. The evidence suggesting someone unknown to the family was responsible has never been compelling. The DNA that was used to clear the family is touch DNA that could have transferred through innocent contact having nothing to do with that night. Meanwhile, evidence suggesting family involvement. Family fingerprints on items associated with the last food she ate. Family fibers in locations that require explanation. Medical findings suggesting patterns that should have triggered protective intervention long before that night. A staged scene with elements that betray intimate knowledge of the family's routines and possessions. Legal strategy that focused on controlling investigation rather than cooperating with it. 29 years of maintained silence about basic questions that remain unanswered. What we owe this child is truth. Not the sanitized version presented in authorized books and friendly media appearances. Not the unsolved mystery narrative that avoids examining uncomfortable evidence. The truth that the physical evidence has been quietly insisting on for 3 decades. That something happened in that house involving people who lived there. That the response to what happened was staging designed to create an alternative explanation. That legal resources were deployed immediately to ensure that the people with knowledge would never have to answer questions under circumstances where those answers could be used against them. That a grand jury examined the evidence in detail and voted to indict. But that decision was sealed for 14 years while the family's narrative took root in public consciousness. That's not speculation. That's what the documented evidence shows. We can't bring criminal charges. The law doesn't allow it at this point. We can't force acknowledgement from people who have spent decades denying what the evidence suggests. But we can insist on looking at what's actually there. We can refuse to accept narratives that require us to ignore physical evidence, timeline contradictions, behavioral patterns, and a grand jury decision that all point in the same direction. We can say, the official story doesn't hold. We can say, the evidence tells a different story than the one we've been given. We can say, legal strategy successfully prevented criminal accountability, but it didn't prevent truth. The truth has been sitting there all along. In forensic reports, in investigative files, in the documented behavior of people who chose legal protection over cooperation, in a grand jury decision that was hidden until it no longer mattered. It's been waiting for 29 years, waiting for us to look past the media narrative and the legal barriers and the authorized accounts, waiting for us to see what's been visible from the beginning. A child lost her life in that house on December 26, 1996. The people who could explain how that happened have spent 3 decades ensuring that explanation would never be required of them. A grand jury believed there was enough evidence to hold them accountable. The legal system decided otherwise. That's the truth the evidence shows. That's the truth we owe her to acknowledge. However uncomfortable, however protected by legal strategy and media management, and the simple passage of time, the evidence speaks. If we're willing to listen,